Should you obtain a medical power of attorney for your child's healthcare decisions? Without a medical power of attorney, parents may find themselves unable to make or even learn about healthcare decisions for an adult child in an emergency. This topic asks whether such a document is needed when children reach adulthood. Under Texas law, parents act as representatives for minors until they turn 18. After that, HIPAA prohibits healthcare providers from releasing information without the patient's authorization. A medical power of attorney can allow a parent or other designated person to obtain information and make decisions if the child is incapacitated. To create one, the principal must be at least 18 and mentally capable, and must sign a written document in the presence of 2 adult witnesses. One witness cannot be the agent, a relative, or an employee of the principal's healthcare provider, ensuring impartiality. The document remains inactive until the principal is incapacitated, and it can be revoked at any time. Should you obtain a medical power of attorney for your child? The article recommends that parents of adult children consider this step so they can access critical medical information and consent to treatment if their child is unconscious or incapacitated. For married children, the spouse will usually have this authority, but for those who are unmarried, separated, or divorced, parents may be the most appropriate representatives. Without a signed document, you may have no legal right to direct your child's care, so preparing a medical power of attorney is a prudent way to protect your family. A medical power of attorney designates a healthcare agent to talk to doctors, approve or decline treatments, and make care decisions if you cannot speak for yourself. It is different from a durable financial power of attorney, which covers money matters such as paying bills or managing investments. A living will outlines your preferences for end-of-life treatment instead of naming an agent. Having all 3 documents can provide comprehensive protection. For young adults, both medical and financial powers of attorney allow parents to step in when legal adulthood limits their access to information. To be valid in Texas, a medical power of attorney must be written, dated, and signed by the principal or someone authorized to sign, and 2 adult witnesses must observe the signature. At least one witness cannot be an agent or relative, which helps maintain fairness. After the document is properly executed, it remains dormant until the principal is incapacitated, and the principal can revoke it at any time. If your adult child becomes incapacitated without naming someone, Texas law allows a spouse, an adult child, all adult children together, or the parents to make medical decisions. Because family relationships can be complicated, your child may want to exclude an estranged spouse or certain relatives, and a medical power of attorney legally enforces that wish. A temporary medical power of attorney grants an agent authority only during temporary incapacity, such as when the principal is under anesthesia or briefly unconscious. This authority ends when the principal regains capacity and can be prepared in advance for specific situations or time frames. Any competent adult can establish one. Creating a medical power of attorney allows families to plan ahead and ensures that a trusted person can act if needed. Without such paperwork, you may not be able to get information or consent to treatment for your child. Because different states and circumstances can affect how these documents operate, consulting a Houston estate planning attorney is advisable. For help drafting or executing a medical power of attorney, contact the law office of Whitney L. Thompson, PLLC at 281-214-0173 or visit their office at 4201 Farm to Market 1960 Road W Suite 360, Box number 116B, Houston, Texas, 77068, United States, where this law firm can guide you through the process.